At a Senate Judiciary hearing on July 23rd, Congress convened to discuss civil rights and DEI. Invited to testify was Harmeet Dhillon, currently the Assistant Attorney General for Civil Rights at the U.S. Department of Justice. Watch key moments from her testimony, including her opening remarks and contentious questioning from Democrat senators.
I am honored to testify on ending illegal racial discrimination and preferences through vigorous enforcement of our federal civil rights laws. I look forward to working with all of you to ensure that we successfully dismantle all forms of invidious racial discrimination from our society. On January 21st, President Trump signed Executive Order 14173, titled Ending Illegal Discrimination and Restoring Merit-Based Opportunity. The executive order stated that race and sex-based preferences under the guise of so-called diversity, equity, and inclusion violate the text and spirit of our long-standing federal civil rights laws. DEI initiatives reflect a set of practices that unlawfully discriminate against, classify, exclude from participation, or deny benefits to individuals based on race, sex, or other prohibited characteristics. The order announced that it is the policy of the United States to protect the civil rights of all Americans against illegal DEI initiatives. Enforcement of that policy is now delegated to me. Just last week, I reached the milestone of my first 100 days in office, and under the leadership of Attorney General Pam Bondi, we have been busy implementing President Trump's bold agenda for ending illegal DEI for all Americans. I will highlight some of our work for you today. Here are some of the ways we have taken steps to end DEI in education. First, as a result of multifaceted investigations into illegal DEI-based discrimination, harassment, and abuse at major so-called elite universities and colleges, the division is now in discussions with many educational institutions to end all unlawful DEI programs throughout these schools, including in their law, medical, nursing, and other specialty disciplines. Second, we are actively investigating several prominent colleges and universities regarding rampant anti-Semitism, resulting in discussions aimed at ending anti-Semitic abuse on college campuses nationwide. Third, starting in April, we open investigations into 50 major universities, 16 top law schools, and 7 medical schools by sending letters requesting any changes to admissions processes post Students for Fair Admissions versus Harvard. We are also investigating racially discriminatory admissions practices at selective public high schools. Fourth, we are engaged in several lawsuits and investigations into Title IX discrimination against the rights and safety of women and girls in classrooms, athletic fields, dormitories, and other facilities. As a result of our efforts, several institutions have reversed course already. Fifth, we are investigating the University of California for its race and sex-based discriminatory hiring practices under UC's 2030 capacity plan. The Civil Rights Division has also acted in various employment-related matters. First, we are investigating Minnesota's hiring and employment practices. State policies appear to require agencies to engage in illegal race and sex-based hiring in violation of Title VII. Second, we are investigating the Hennepin County Attorney's Office policy that requires race-based decision-making in plea agreements. The investigation is ongoing, though that office has refused to cooperate with our investigation. Third, we're investigating Rhode Island regarding its affirmative action plan that sets race-based hiring goals across its government. In light of Rhode Island's refusal to cooperate, we're assessing our next steps under Title VII. Fourth, we're investigating Chicago's racially discriminatory hiring practices permeating its government. This is just a small fraction of the extensive portfolio of actions we have taken toward ending DEI in my first 100 days in office. Every day, my team assesses new opportunities to combat invidious racial discrimination, from diligently pursuing investigations to drafting and filing federal civil rights lawsuits. The Civil Rights Division strives to protect the civil rights of all Americans against illegal DEI initiatives. In his famous dissent in Plessy versus Ferguson, Justice John Marshall Harlan wrote that the law regards man as man and takes no account of his surrounding or of his color when his civil rights are guaranteed by the supreme law of the land are involved. Nearly 130 years later, Justice Ketanji Brown Jackson echoed this sentiment in Ames versus Ohio Department of Youth Services, writing that The Civil Rights Act prohibits discrimination against any individual because of such individual's race, color, religion, sex, or national origin. While the division's jurisdiction is governed by statute, we work closely with the chair of the EEOC and heads of other executive branch agencies to combat illegal DEI initiatives and to uphold the civil rights of all Americans. With these efforts underway, Senators, the goal is clear. Either DEI will end on its own, or we will kill it.
I want to ask you a question about Texas redistricting. As you know, President Trump has recently encouraged, I'll use that, Texas Republicans to do mid-cycle redistricting in order to gain more seats in the House of Representatives. I understand that after the president made that decision or that announcement, you personally sent a letter on July 7 to Texas in your capacity as Assistant Attorney General, arguing that 4 Democratic districts violate federal law. Is that the case?
It is the case that I sent a letter under my authority to administer the Voting Rights Act and indicate that in light of our analysis of 4 so-called coalition districts in Texas, that those districts were inconsistent with the Voting Rights Act.
And the date of July 7 was just coincidental, that it occurred after the president had called on the Texas legislature to do mid-decade redistricting?
I don't remember what date, Senator. I probably sent 300 letters since I've been in this office. And so what I can say is that I send no letter or make no request without proper investigation.
Have you sent any other state legislature a letter where you have indicated that districts within their state are in violation of federal law?
Not yet.
More redistricting to come?
I don't know. I have to investigate the facts.
Are the race-neutral policies like those used by University of California, which Justice Thomas explicitly praised in that opinion, now considered by you to be illegal DEI?
Well, Senator, first of all, the investigation that we've opened is an investigation, and it's an investigation into the hiring policies of the University of California system, not the admissions policies. That said, I have absolutely seen abuses in the admissions policies in using race as a crude proxy for discrimination.
That's not the question I asked you. Are the race-neutral policies praised by Justice Thomas now considered by you to be illegal DEI?
I think you're mixing apples and oranges, so
well,
I can't really answer your question.
You can answer my question and say, yes, they are now illegal. That is what Justice Thomas praised in terms of race-neutral policies, which include preferences for low-income applicants, first-generation students, things like that. Are you now saying that what Justice Thomas praised is now illegal in your view?
Senator, there's a difference between what you see on paper and what you see in reality, and I reject your premise.
I'm not asking you about particular.
I reject your premise that how California describes its
practice.
admissions
I'm asking
practices
you
is
about whether
reality.
you subscribe to the Supreme Court's opinion or whether you disagree with Justice Thomas' concurrence. You can answer that question, can't you?
In the abstract, yes. In reality, what you're describing does not exist in the UC system.
For more clips like this, stay tuned to Congress Clips. And thanks for watching.